Appeal dismissed.
Item number 1. Item number 1.
Appeal dismissed.
Offline.
May I, Your Lordship?
This item 1, criminal appeal, in view of the IA, you dispose of that. In view of such, IA stands disposal in the IA.
May I, Your Lordship?
Yes,
I beg to mention item number 8, Your Lordship.
8.
Here we have not filed counter affidavit. So, Your Lordship, at least 4 weeks time may be given. We have not received the Paravai's reply also. I've informed the other side.
On the prayer of MS Kipango, learned counsel for the learned state council, list this matter after 4 weeks,
Yes.
so as to enable her to file
And also,
the opposition on behalf of the state.
and also item number 13.
4 weeks.
And also item number 13, Your Lordship.
13.
Same prayer, Your Lordship.
We'll see its orders. We'll see.
Okay, Your Lordship.
May Your Lordship.
Yes.
Lordship, I beg to mention item number 16, Your Lordship, supplementary
16.
hearing.
Yes.
May I pray, Your Lordship, this matter may be listed on 30th of this month.
Why?
Today, Standing Counsel for the Commission is not present due to some personal difficulties, Your Lord. So consider.
Otherwise,
Any surviving issue?
Malad, it's there, Malad, because surviving issue is, Malad, that appointed, the one post is kept reserved.
2018,
18, Malad.
17 or 18?
It's 18, Malad. 17, Malad. Final, the selection process was done in the 2019, Malad.
19.
Yes.
Is
Admitted
there
of 17.
any direction to keep one post?
Yes, it's
Yes, it's
there,
free,
Malad.
Your Lordship.
You appoint her, appoint him.
Malad, that is the only
Your
thing.
C.
He, Malad.
He
Lordship.
appears to have qualified.
Yes, Malad.
You have the interview and appointed him. What's there?
On 30th, Your Lordship.
13.
Lordship.
30.
30. 30 of this month.
Are you disputing
Yes, Your Lordship.
that he doesn't?
Lordship.
score-
They have put to
score-
challenge
score-
the
Malad,
PWD
it's not
reservation. rules.
disputed, Malad. They are not disputed.
What is dispute?
What they disputed is that the criteria of the manner in which this computation has been done, computation.
A computation of the
Yes, reserve quota, man.
reserve quota.
Now they're saying that get reservation to the PWD, that to entitle for reservation PWD, first you'll have to.
These
you-
are all settled methods.
Yes,
So
it's all
that's a-
settled matter. That's but
what is the law?
law says that, my lord,
What is the law?
it's a horizontal
What is
reservation.
the judgment of Supreme Court?
Yes, my lord, it's a well settled, my lord.
So ask.
My lord, it says that in case.
Where is the Supreme Court judgment?
Yes, it's
On
here, my lord.
Computation.
Yes, it's there, my lord.
Where is there?
Anil Kumar,
It's all settled. You can't.
It's all settled, my lord.
New criteria or the procedure of computation.
Rajesh Kumar Dauria and Anil Kumar, it's all well settled, my lord, long back.
Lordship, for final disposal on 30th. On 30th of this month.
My lord,
Are you still not employed?
my lord, no,
Not yet
my
employed.
lord.
So you,
I'm
are,
waiting, anxiously waiting for this, my lord.
so you are not looking for other job.
My lord, since it is, I'm waiting for this, my lord. And now after this, my lord,
the interregnum, there are lots of
Yes.
advertisement.
yes, my lord, after this,
examination.
the put to challenge, this advertisement and the selection was put to challenge, that there's because of the chaos in the FPCS, madam, even fresh advertisement has not been, even the press advertisement that has been cancelled, madam. As of now, the technical advertisement, technical engineering, madam.
So you have lost your interest to participate in news recruitment process.
Madam, even still this is not yet settled, madam. Even the fresh recruitment is yet to be. But now since My legitimate right is there, my lord, in the previous recruitment.
Legitimate, I'm not saying that you don't have, but then the way you get the things on your own merit
My lord,
is something,
that is there. My lord, in
something to be cherished or celebrate,
my lord, in this case,
not under some quota or something like that.
my lord, in
Anyway,
well,
not Mr. T. Tagum, London Council for the Petitioner. MS N. Anju, London Council for the Petition, London Council appearing for the Public Service Commission. Submits that. London Senior Counsel Mr. Ajinapa appearing, the London Standing Council for Public Service, or much APPSC, huh?
my lord,
APPSC is indisposed today, for which he prays for listing the matter on 3009/2024.
Obliged.
Whereas a lot list accordingly.
3009.
List on 3009/2024.
Deeply observed.
Your Lordship, I would like to mention item number 7. Your
Seven.
Lordship, may kindly take up this matter after 3 weeks, Your Lordship.
Yes.
Your Lordship, cannot take up this matter since in earlier round of litigation,
Okay.
petition 230 and 2015 had appeared in connected matter.
Okay.
So this before any other.
List this matter before any other appropriate bench without me.
Highly obliged.
Have you not checked it out?
I have checked it, Your Lordship.
Then why have you mentioned?
May I please,
Yes.
Your Lordship? Your Lordship, I would like to mention item number 9 on behalf of the party.
Item
Item number 9, Your Lordship.
9.
Yes.
Yes.
This matter may be fixed on 24th of this month because a similar matter has also been listed on this same day, Your Lordship.
Why don't you file
My lord, we'll be
Reply.
filing, my lord, the
you file it
instruction.
before 24?
My lord, we'll try, my lord.
That's the reason we would not like to fix the matter within a short time. Because they don't file counter affidavit and you again makes a mention on the other day because of your insistence only this matter was fixed today,
Yes,
not even 1 week, isn't it?
yes, my lord. The instruction, my lord, I've received, my lord,
We'll have to be careful again next time.
Yes, Your
guideline,
Lordship.
the relying, my lord, it's not enforceable. That's instruction. Now for that,
Don't simply say enforceable. Why? Are you following that or not?
no, my lord, it's not following, my lord. My lord, for even every case, my lord, wherever the regulation has been done, there's a policy decision, my lord. In this case also, my lord, we have put up for relaxation of the RR. But now the APCS and administrative reform that declined, they disagreed with the proposal, my lord. That's because of that, there's problem, my lord.
Item 9, huh? As agreed to by the learned counsel for the parties, Mr. E. Pine,
Yes, Your Lordship.
E. Pine, learned counsel appearing on behalf of Mr. T. Patil and Mr. T. Tagum, learned standing counsel for Health and Family Welfare Department. Health and Family Welfare Department list this matter on 24.
Yes, Your Lordship. One more,
24/09/2020.
one humble prayer, Your Lordship. Along with WPC 384.
So and so. You give the number.
Yes, Your Lordship. Deeply
You-
obliged.
on the next date, learned council, on or before the next date, the learned council, learned standing council is directed to file
My lord,
the response on behalf of the state.
deeply.
Number 1, item number 2.
May it please, Your Lordship.
Yes.
My
Kaushik,
Lord, on the yes, my Lord. The last occasion, my Lord, an attendance sheet was submitted by my learned friend, my Lord. Lordship wanted a clarification, and to that effect, my Lord, we have filed an additional affidavit in para 1, para 4 of page 156 of the additional affidavit. We have clarified that on the date when this technical evaluation was done, my lord, on that day inadvertently we signed in place of KK Enterprise. Para 4, my lord, will kindly see. 150 space 156.
Yes.
Lordship finds the deponent state that on the day of opening of the technical bid of NIT dated so and so, though the deponent went as a representative of the petitioner, but due to inadvertent error on the part of the deponent, he signed in the attendance sheet on behalf of so and so instead of the petitioner. Moreover, the person who has signed the attendance sheet on behalf of the petitioner is not an authorized representative of the petitioner, neither in the technical bid nor in the financial bid. Therefore, the allegation so and so is not correct. But it's an inadvertent error in against the petitioner firm. Somebody else has signed, and I signed against the firm named KK Enterprise.
Where's your authorization?
Madam, I am the authorized representative. Madam, I made it.
Where is your authorization?
Madam, that authorization we have not annexed, but
You have to annex.
Madam. No, Madam, they are not disputing that I am not the authorized representative of this petitioner firm. They are trying to show that I also am an authorized representative of some other firm. In fact, my lord, on the day when the evaluation is done, the practice is, my lord, we need to carry an authorization letter. We submit before the authorization letter, and only then we are allowed to enter in the hall.
So you show us your authorization letter on behalf of the petitioner,
My lord.
not on behalf of. Do you have any records to show that he
My lord,
has submitted the authorization letter? It's just they just show and you allowed and
the petitioner has playing serious fraud with this honorable court.
yes.
Now, there is authorization letter by the KK. There is record to show.
There's a record. Sir, you have not been briefed properly by your.
No.
He represents KK both in technical and financial bids.
What is this?
But as per my instruction,
That's the reason you have not been properly instructed and you have not been, I think your client is misleading you. You have to be very careful. See, if you have asserted that you have been authorized only by the petitioner and not by one KK, you have to substantiate that you'll have to annex the authorization. They are producing this authorization on behalf of the Messrs. KK.
is it the name of
I will direct them to file, bring on record, and we'll
my lord?
decide the matter. It's very serious.
Absolutely, my lord. Absolutely. If that is so, my lord, let them bring on record, my lord. I'll also get a chance to, my lord.
This is something, Kaushik, you will have to be very careful.
Yes, my lord. My lord, so far my instruction, my lord,
Yes, you are taking it serious exception.
My lord, I'll
something not done.
My lord, if that be so, my lord, as a counsel of this court, my lord, I will never appreciate.
That's why I'm just indicating.
I'll never appreciate all this.
It could happen to you. It could happen to anybody else.
Right.
So you'll have to have.
The lordship will kindly appreciate that we rely on the instruction which is given to us by our client.
You bring on record.
Yes.
We'll
Let them bring it.
instead of entering into the merit, we'll decide this matter.
Yes.
Heard, Mr. B. Kaushik. What is this? The counsel for the petitioner. This court. On 09/09/2024, considering the allegations and counter allegation by the parties with regard to the authorization to represent the firm The farm is also a writ petitioner.
For the writ petitioner is Eka Enterprise, my lord.
Writ
Only
petitioner.
farm.
And the and considering and the documents and the document produced by the Mr. G. Tarak, Standing Council for RWD, shows that who showed the which showed Mr. Roy Yangpo. Who has filed the affidavit in these proceedings in respect in support of the writ petition is in fact a representative of one other other firm, namely KK Enterprises. Yes. Granted, the learned counsel to the petitioner to obtain instruction. Today, the learned counsel has filed an additional affidavit stating that on the day of opening of the technical bid of the NIT dated 05/07/2024, though the deponent went as a deponent represented the petitioner, but due to inadvertent error on the part of deponent, he signed in the attendance sheet on behalf of MSKK Enterprise instead of the petitioner. The person who has signed the attendance sheet on behalf of the petitioner is not an authorized representative of the petitioner, neither in the technical bid nor in the financial bid. Therefore, the allegation, the allegation made by the allegation. Therefore, he has refuted the allegation. No. The allegation made by the standing counsel for the RWD is not correct. The deponent, Mr. Sri Roy Yangpo, clearly stated that he is the authorized signatory of the petitioner in the technical bid, signatory of the petitioner, and has no connection with one MSKK Enterprises. On the perusal of the additional affidavit, next para, this court finds that no authorization has been annexed as to substantiate the claim of the petitioner, a claim of the deponent with the additional affidavit. Rather, the learned standing counsel, Mr. G. Tarak, has produced a copy of the authorization letter addressed to the executive engineer, which shows that the deponent is the deponent, so that the deponent has been authorized by one MSKK Enterprises to represent the farm. Mr. Facing with such situation, Mr. B. Kaushik Learned Counsel for the deponent oblique petitioner fairly submits that he may be allowed some time to obtain further instruction. You
Ma'am.
obtain further instruction.
Yes, yes, of course, ma'am.
You grill him and
Yes.
get the truth out of him.
Yes, absolutely,
Alright.
Malord, absolutely. Yes.
The prayer made by learned counsel for the petitioner, oblique deponent, is allowed. Please stop. The learned standing counsel to bring on record the documents he has produced today. That is, i.e., the authorization letter. Please stop.
And also
The-
attendance sheet of both technical and financial. needs.
Any other documents?
Yes.
Huh?
Ma'am.
Next paragraph. It is this code. No. In view of the circumstances arisen in this proceeding, this court is constrained to take a decision, take a call on the issue which has arisen by taking serious exception to the same before entering into the merit of the proceedings, which may entail serious consequences to the parties. List after 3 weeks.
Yes.
Yeah.
Now this.
I'm absolutely sorry, Malord. I was not apprised about this, Malord.
Yes.
Item number 3.
No ground. What is your ground?
Lordship, I have my daughter who is 40% permanently disabled and she is appearing class 12 this year. And she is completely depending on me.
Heard Mr. Arkoyo. Yes, dispose of the representation. That's all.
Lordship, at least till my daughter.
7 days. 7 days. Within 7 days, you dispose of the representation. Till then, that's all. Not more than that.
Lordship, at least,
Or Mr. Arko, learned counsel for the petitioner. And also her Mr. Titago, learned standing counsel for the standing counsel, comma, Health and Family Welfare Department, Government of Arunachal Pradesh, representing all the respondents.
Yes, my lord.
Next paragraph. Considering the nature of prayer and the grievances raised, comma, this petition is disposed of at the motion stage itself. This next paragraph. The petitioner. Who are you?
I'm doctor in impugn number, serial number 14.
Next paragraph. The challenge made in this writ petition is to the impugn order dated 20/08/2024, issued by the Commissioner within bracket Health and Family Welfare, Government of Arunachal Pradesh, whereby as many as 31 medical officers within bracket GDMO allopathy, all allopathy,
All alloptic.
GDMO allopathy, bracket close, including the petitioner. In respect of the petitioner who is sought to be transferred from where it is your name?
Serial number 14 from
Who is
Sile.
who is sought to be transferred from PH Sile under DMO Eastern District to District Hospital Hailia under DMO Anjo. The petitioner is SMO within bracket SG within bracket allopathy. Allopathy or allopathy?
allopathy.
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 Allopathy within bracket allopathy. How long you are there?
3 years.
Who is working? Who is serving? Is at PHC, Sile on being posted in the year
2021. 21.
on being posted in the year 2021 for the last 2 years, 3 years. List of the petitioner has challenged the impugn order on the ground that she has filed a representation that on 27/08/2024 before the respondent number 2. Who is respondent number 2? Commissioner.
Commissioner.
Respondent number 2.
Yes, my lord.
Commissioner.
Commissioner, my lord.
Commissioner, within bracket Health and Family Welfare, bracket close, Government of Arunachal Pradesh for review public retention of the petitioner at Sile at PH Sile on the ground of that her daughter, who is a special child with 40% permanent disability, needs her care and nursing, who is care and nursing wisdom. Her daughter is studying in class 12. Who will be appearing for CBSE examination 2024 to 2025 in the month of February to April 2025 from Siang Royal School, Pasigar, East Siang District. The other ground which the petitioner has projected is to the effect that the transparent posting guidelines, a policy dated 18/11/2023, which regulates the transparent posting of doctors serving under the Department of Health and Family Welfare, Government of Arunachal Pradesh, has special emphasis on the timeline, medical ground and reliever. However, while issuing the impute transfer order in respect of the petitioner, the authorities have failed to consider the condition stipulated under the applicable guidelines, under the aforesaid guideline policy. The Mr. Arkoi learned next period. Arkoi learned counsel for the petitioner submits that apart from the hardship that would be faced by the petitioner in view of the in view of her daughter being a special, why a special child? Child or child? We
Because
should love every child.
She's
Why a special child?
disabled child.
Every special child with 40% permanent disability.
Child with special needs.
Ah. Consider having the child which needs special care, having 40% disability, which needs, who needs special care, and the examination that would be examination of class 12 that would be held in the month of April 2025. Is the child is studying in Siang Royal School, Pasigar, East Siang District. And also the non-consideration on the timeline and other medical grounds, the transfer, impute transfer order in respect of the petitioner is not sustainable. It submits that the respondent authorities are duty bound to consider the hardship faced by the petitioner and also to follow the profess norms as enshrined in the transfer-based posting policy dated 18/11/2023. He further submits that since the petitioner has moved an representation for her retention on the above grounds, the respondent authorities may be directed to consider and allow the petitioners to continue at PHC, Sile till till the month of May 2025. 2025. Please do. Next paragraph. Mr. T. Tagop, learned standing counsel, clearly submitted. He would not have any objection as regard disposal of as regards disposal of the representation by the respondent authorities. Next one, having considered the submissions, I'll not comment on the merit.
Lordship,
If I comment, it may be, they may negate your without commenting on the merits of the claim of the petitioner, I deem it appropriate to dispose of this writ petition with a direction to consider and dispose of the representation filed by the petitioner. Mr.
So in that case, I shall resubmit the representation covering all the specs.
Accordingly, the petitioner, accordingly, the respondent authority, particularly respondent number 2,
Yes, ma'am.
Commissioner,
Commissioner, ma'am.
Within bracket, family and health and family welfare. Bracket, government of municipality to take on the file of, take on the representation of the petitioner and consider and dispose of the same within a period of 15 days. 15 days.
My lord,
15 days.
20 days because
Why are you not disposing?
I'll
He
submit
is
this.
the one who will dispose of the representation. Why you are asking for that time?
I'll submit again, sir.
I'll provide you. In a period of 20 days.
My lord, all right.
Within 20 days from today, the petitioner may file a detailed representation in addition to the is at liberty to file a detailed representation in addition to the representation already submitted by the petitioner. That's it, 27/08/2024. The writ petition is still disposed of.
Item number 4.
Lordship, interim stay on.
Okay. Till the disposal. Before that, huh? Before this disposal, huh? Before that. Till the disposal of the representation, the impugn order, that is 20/08/2024, in respect of the petitioner, shall not be given effective.
Much deeply.
Item number 4.
Yes.
May I please, Your Lordship?
Yes.
Your Lordship, I'll file additional. Your Lordship, in this case, the petitioner, they are brother and sister, Your Lordship, and our father, he was appointed as a cattle attendant in the year 8 February 1973 under the Office of Joint Director, Composite Livestock Farm in the Department of Animal
Animal Husbandry and Veterinary and Dairy Development, Government of Arunachal Pradesh, Your Lordship. And my father retired on 13 March 2007, Your Lordship. However, my father died on 18 July 2007, Your Lordship. And my father died without applying pension scheme, Your Lordship, due to ignorance and lack of education, Your Lordship. He was an illiterate person, Your Lordship.
Ignorance is no excuse in law.
Yes, Your Lordship, but he was illiterate, Your Lordship. He couldn't even sign on a paper. I mean, he was using just thumb impression, Your Lordship.
What do you mean by unlettered?
It is illiterate, Your Lordship.
What do you mean by unlettered?
Yes, it's mean illiterate, Your Lordship.
Its meaning is illiterate.
Yes.
Okay.
Yes. So there are thus he didn't apply any pension scheme. And when I went to the department to inquiry,
When did you go?
yes, Your Lordship.
When did you go?
Your Lordship, I have
Which year?
Your Lordship, in my annexure 1, page number 18, Your Lordship.
Page number 18.
Yes, page number 18. Your Lordship.
2024.
No, not
That's
2024.
something. When did you approach?
Yes, long back, Your Lordship.
When?
It
Long
was.
back when?
I have not specifically mentioned the date here, Your Lordship, but
But also,
yes, Your Lordship.
most probably you are literate.
Yes, Your
You
Lordship.
are not unlettered.
Yes, Your Lordship.
Okay. Then
So I went to the department, and they have suggested me to take the requisite document as such legal hair certificate and all, and death certificate and all, and that I have duly obtained from the.
when?
Yes, Your Lordship. It is annexed in annexure.
So when did you? I just wanted to know, when did you approach first?
Yes, Your Lordship. I'll
Which
check.
year? Your father died in 2007.
Yes, Your Lordship, 2007. At the time we were minor. At the time we were very young, Your Lordship.
Very young or minor?
Not minor, but we were very young. So we didn't have the idea about this pension
Who
scheme.
is this petition number 1?
Petitioner number 1, he is the brother of this petitioner number 2. He is
His name is there.
yes, his name is no, not even his name is there.
So why you are particularly asking that name of your sister
Yes, Your Lordship.
should be there? Not why not you?
Yes, because Your Lordship, since my sister, she isn't married, and then we all have family, and I have my source of income, so that's why it will be for the.
Yes. Take a sympathetic view. What's these about things? If it is permissible under the law, don't go for a technical thing.
This is my
You're
humble.
asking for a pension, family pension only.
My humble edition, let notice be go, my lord. It
You
involves.
should notice. Because these are very difficult, but then there is certain rules and the procedures to be followed. Is that it?
Yes, ma'am.
Customer wants to add, it was born in 2007, was 6. Father died in 2007. So
No,
of course
it's
now,
okay.
now she's 18
It's
years.
not that she was born in 2008 after the death of his father. Even if,
No, not
even if,
before death of his father.
even if she was born in 2008,
Service book, her name is not there.
obviously, you cannot dispute that she's not
No, I'm not.
His
disputing.
daughter. At least 1 year and within 9 months after the death also you can. Anyway, you should notice nothing
Yes,
else today.
yes.
Third MS
Eighth alum.
learners for the petitioners.
Yes, Your Lordship.
By filing this petition, the petitioners have prayed for a direction to the respondent authorities to add the name of the petitioner number 2, namely MS Techi Menyo, in the family declaration form of the service book of her father, late Techi Peki, who had died in the year 2007 while serving as while serving. He
Yes.
died while serving.
Yes, no, he was, after retirement, he died, Your Lordship.
Okay. Who has died in the year 2007 after retirement from his service as cattle attendant under the Office of Joint Director of Composite Livestock Farm, Government of Arunachal Pradesh, New Zealand, in the Department of Animal Husbandry, Veterinary and Dairy Development. List of the late father of the petitioners had served the department from 1st of March 1973 to 31st/03/2007. Issue notice returnable by 3 weeks. Since Mr. Who is for one?
Me, my lord.
Mr.
1, 2, 3.
El Permit, Learned Counsel, Learned Standing Counsel for respondent number
1, 2, and 3.
Learned Standing Counsel for, what is that department?
Animal husbandry and
Husbandry
veterinary.
and Veterinary and Dairy Development. And MSG at the Learned Additional Senior Government Advocates have entered appearances and accepted notice on behalf of all the respondents.
4 and 5, was it?
No formal notice need been served. Have extra copies so and so, huh? This after 3 weeks.
Item number 5.
Yes,
Lordship, here petitioners were appointed as contractual.
very strange. It goes. Since you have accepted the regularization, your contractual things goes. It's a fait accompli.
Lordship, while we were working,
How you have applied your mind?
Lordship, while we were working as
You are saying that the termination of your regularization, your termination is in respect of your regulation as a PRT.
yes,
There's no mention or there's no mention of your contractual appointment. How you have regularized? Assuming that your regularization is legal, by virtue of you being appointed as a contractual teachers, only according to as per the policy you have been regularized. Once you are regularized, it goes. You have to forget that.
however, Lordship,
It should not come to your dream event.
Lordship, we have no control over the regularization because
It's
we
not
were,
right. Regularization, did you accepted the regularization? No.
we have accepted, however,
Then once you are accepted the regulation, the basis of your regulation, whatever may be the policy, as projected by you too also that in view of your contractual service, there is a policy of the state that this certain percentage of the teachers vacancies shall be regularized from the contractual teachers. So maybe wrongly or rightly you have been regularized. Now, are you challenging the termination order?
we have challenged the termination order in other writ petition. We
Okay,
moved,
it's pending.
it's pending. However,
So-
Lordship, that,
Withdraw.
Lordship, at least
Otherwise,
then in that case,
if I pass, then on merit, it may affect your.
Lordship, in that case, I have already submitted representation
It's
because
all right.
Lordship,
You
the
don't have the
regularization, Regularization was not because of my fault. We have submitted our representation.
Then why you have accepted that? You have not been picked up from the market and regularized.
No, Lordship, we
Then
have
you were-
submitted our representation in accordance
you
with
were
the.
appointed as on the contractual basis. There's a policy of the state. Assuming that policy is right, correct. Then thereafter only your service has been regularized. Considering that you have worked as a you were working as a contractual teacher, that's all. Once you accept the regulation, nothing remains. See, if I dismiss on the writ petition on merit, it will have a implication because the dismissal will have to record the reasons for dismissal.
In that case, Lordship may dispose of by,
No, sir.
I have submitted my representation because Lordship, these are not at all on the, I have not
See,
submitted because.
once your regulation, once you have accepted the regulation, this contractual appointment, the basis is what? I'm just repeating it. You have not been picked up from the market and then regularized. You have been regularized. By virtue of you being working as a contractual teacher, that's all. Now, the regulation was, it was legal or not legal, it's a different thing altogether, which will be considered in it. But by this writ petition, just because that the termination doesn't talk about or mention about your contractual appointment of teachers, you cannot claim that. This is elementary. We don't have to put, track our mind on this.
However, Lordship,
Unnecessary, why tracking our mind? This is elementary.
Lordship, however.
At least I believe, this court believes so.
However, I'm repeating this because
I'm
the
repeating again. I don't want to repeat.
the regularization process, without our fault, we don't have control over the authority. They have regularized on the basis of policy decision. Now
Then
some
why,
have,
Why did you accept that?
because we were of the bona fide impression that this is the way the regularization is being processed. Otherwise, why should we I have.
So us where how is your initial appointment? Then we'll decide on merit. Where is your initial appointment? Initial appointment
Lordship, at page number 19.
19.
Yes. Initial appointment as a contractual teacher, 2009.
Chukutaja is hereby engaged as junior
19
teacher
is,
of
Godak
business
Joni.
SSA in the fixed pay of so and so, block so and so, government so and so for a period of 1 year. He is posted as a so and so. Is it in accordance? Have you participated in any selection process? Was there any recruitment? Was there any advertisement?
Initial appointment.
Yes.
Yes, initial appointment we have participated.
Yes, where it is. What it doesn't indicate. It doesn't indicate in pursuance of the so and so recruitment process.
However, Lord, this is a contractual appointment. SSA was the flagship program of Government of India.
No,
And,
it doesn't mean that even if it's a flagship program of Government of India, you just the authorities can pick up at their own choice. It has to be followed by the certain minimum a procedure of rules or selection process. So as your initial appointment was in accordance with rules.
So in that case, maybe dispose of by considering because my representation is pending before
No,
the
your
authority.
representation cannot be considered. If we find something that your right to be considered is not been considered, then only they will direct. We find that you don't have a right to be considered.
Lordship, at least we should be appreciated because we were working as a
Kindly,
contractual
you-
teacher for
you
11
try-
years. And
Kindly,
my tender age of
kindly-
participating any advertisement, any job.
kindly you try to appreciate. Better you pursue that writ petition.
In that case, may direct the authority
Unless-
because
No.
they are sleeping over the presentation. If in case this honorable court is
This representation it doesn't deserve any consideration. You are appointed on contractual basis, without following the rules. The authorities, they have regularized your service, maybe following some certain policy, but it is bound to be illegal. And you have consciously you have accepted the regulation. The moment you accept the regulation, contractual appointment goes.
However, Lord, in a similarly situated case, there is
What? Similarly situated case?
this honorable court has granted interim. However, in my
What interim?
interim against, because I have no any,
Where it is?
no, I have not annexed, but
Who has granted interim? For what purpose?
My lord,
This court.
it was regarding contingency service, my lord. The serving contingency, the contingency staff, they were regularized by the same patient, my lord, the same style. But they put to challenge that their regulation was cancelled. And thereafter that cancellation order was put to challenge. And during the pendency, my lord, they were allowed, they were been working as a contingency, my lord. That in that aspect, my lord, they were
Where is
allowed
that?
to.
Where is that?
I have not printed. It's
But I'm not passing any order. I'm firm about my view. It's an interim order. It's not a final order.
It was
Even
interim.
if it's a final order, I'll have a different opinion. This cannot be.
Lordship, at least appreciate because we were appointed at the tender age of 25. We worked for 11 years. Suddenly they have terminated us. Now we are jobless,
You are overaged.
overage. Based on that regularization,
On all human consideration, which normally the courts should not be swayed away.
therefore my prayer is only for
Unless this is great for employees or something like that. You are a teacher. You try, heard Mr. Arko, learned counsel for the petitioners. How many petitioners?
4.
Petitioners. By filing this writ petition, the petitioners have sought for a direction to reinstate the petitioner to the original and substantive post as contractual teachers under ISSC/SSA and allow them to continue to serve as contractual teacher at their original place of posting, and also by maintaining by maintaining their original seniority post under seniority position as the termination of their regularization, which order? By termination of their
20 June.
regularization order, where it is?
20/06/2023. This is the termination of origin my regular 20/06/2023, page
Where-
number 29.
Termination of their regularization. 29,
Yes, 29.
regulation that is 20/06/2023 is with regard to the
regularization.
with regard to the regulation and not the contractual appointment under the scheme, under ISAC, public SSA. Issue notice returnable by 6 weeks, 4 weeks.
In the
Since
meantime,
with the
Lordship,
data of London additional, London Senior, London
Standing
Standing
Council.
Council, Education Department, accept notice, entered appearance and accepted notice on behalf of all the respondents.
My lord.
No formal notice need be served, except for this. Otherwise, I would not have issued notice.
much obliged.
Concentrate on that writ petition, not this writ petition. Yes,
My lord, this writ petition is filed by the state, my lord. My lord, the micro and small facilitation council, my lord.
why the state has to file a writ petition?
Because it's
What,
by there is an direction to the respondent, petitioner number 2 to pay 80 crores, my lord, without any basis.
we'll just issue notice.
My lord, there is an execution petition also filed.
Can we stay the execution?
Yes, my lord. When the award itself is in total violation of the act, my lord. Neither the procedure was followed
Why you have not challenged the award? Where is the award?
at page 99, my lord. Yes, page 99. It's in the form of a minute submitted. Relevant portion, my lord, I'll, para 2. In the meeting, both the petitioner and the representative of the respondents were present. The council heard both the parties. During deliberation, the petitioner made a total claim of 139 crores, so and so, as pending liability. The amount having been worked out as per norms of MSMED. It was admitted by respondents representative that from the record it could be
Is
arrived
it,
at the claims.
It falls under the MSCD Act.
First of all, the claim itself does not fall under the MSMED Act because these were works which were entered into prior to the registration of the respondent number 3 as under the MSMED Act. And the first work
Where
is
is
of
that MSCD Act?
MSMED Act, my lord. I have a clear judgment of the Honorable Apex Court, my lord, with this regard.
What is your submission?
My lord, 3 grounds, basically. First,
What is the most potent ground?
most important ground is that registration is subsequent.
Not important, potent. The most potent ground,
Potent ground is that all the three grounds, my lord.
equally potent.
Yes, my lord. The registration is subsequent to the entering of the contracts, my lord. So,
Registration is subsequent to all the contract.
all the contracts. All the contracts were prior to 2016. This registration is of October 2016.
Prior to 2016 and registration is 2016.
Yes.
Then
Then the procedure followed. Section 18, which emphasizes of either conciliation or arbitration. Neither has been followed. And the amount arrived also, there is no basis. Why? How? There is only 3 meetings held. 3 meetings only without recording anything.
who has referred to the council?
The respondent number 3.
Not you.
No. This is, and thirdly, the work in question. Work in question also is not a pure case of supply of goods or rendering of service. It's a works contract, my lord, consisting of many components. Construction, excavation, concrete.
No, works contract can be, it involves the supply.
It
Contract of
involves,
work
it
supply.
involves supply also, It involves construction also, fabrication, installation, all. Construction of 3 bridges.
Yes, heard Mr. N. Ratan, London, Additional Advocate General for the state oblique state petitioner, petitioner state, huh? Petitioner state. Right,
Yes,
petitioner state.
yes.
The
Petitioners,
challenge made in this writ petition is to the order dated 12/03/2024. 99, page 99.
yes, my lord. There is sign on,
Not
12
what,
kilo-
this is an order, it's minutes of the meeting.
yes, sign on
Order is
12,
there.
12 March. This is the order itself. This is minute
Order
of,
oblique minutes of meeting
yes, ma'am.
by the Micro and Small Enterprises Facilitation Council, issued by the chairman cum director within state MSE FC bracket close, Government of Arunachal Pradesh. Whereby an amount of rupees 80 crore whereby the council has directed the respondent, petitioner,
Number 2.
petitioner number 2 to settle for rupees 80 crore only as pending liability within a period of 45 days as per the provision of MSME Act 2006. You write the thing, huh? You write the full this. Then you write in short MSED Act, huh? 2006. Failing which the compound interest and monthly interest to the supplier at 3 times bank interest is to be paid. The council has further directed to, has decided to close the case and inform that the petitioner and inform the petitioner granted the petitioner, the respondent number 3,
Yes, ma'am.
respondent number 3, liberty to approach any other appropriate forum in case of non-receipt of payment. Please stop. The further challenge is the notice and order dated 28/08/2024 passed by the district and session judge, Pasigar, in THG execution petition number 3 of 2024. Within bracket MS Tama Publication Works versus State of AP and others. Whereby a notice has been issued to the petitioners for execution of execution of the order dated 12/3/2024 passed by the Facilitation Council MSEFC. No, facilitation council. Passed by the Facilitation Council, MSEF. Facilitation Council Micro and Small Enterprises. Mr. N. Ratan, Learned Council to the petitioner submits that the work contract, the contract in question is a work contract which doesn't involve the supply of, which doesn't only involve the supply of what?
Goods
Goods
or rendering of services, simply stated.
and rendering of services, but also involve other and
Construction.
involves other construction
Yeah.
works which cannot fall under the purview of MSMED Act under 2006. He submits that the works, the contract works, the work contract is of 2000, is prior to 2016, before the 2000,
Prior to
prior to
2016, my lord.
2016.
Before
Whereas
the-
the registration of the respondent number 3
Yes.
under the act is on 2000, which month?
October.
In the month of October 2006. For which the provisions of provisions of the MS
No, is September.
September, huh? September
15/9/2016.
29 September 2000, 29/09/2016, huh?
15/9/2016.
15
Podium registration is 27/10/2021.
15/9/2016, which shall not fall under the purview of MSMED, Act 2006. He further submits that what is your further submission?
Section 18, the procedure prescribed under section 18.
He submits that he submits assuming that if it falls under the purview of MSMED Act, he submits that the relevant provisions as provided under section 18 of the Act has not been followed. Therefore, the impugned order is illegal and unsustainable, and the consequential proceedings order that it's so and so that passed by the district judge, learned
22/8.
district so and so is also not sustainable. Issue notice to the respondents, all the respondents,
Yes, ma'am.
returnable by 4 weeks. Next period. When you are supposed to appear, notice?
On 5th of October.
Then we'll fix on 4th of October, because you will be passing the 3rd of October. What do you say?
Well, prima facie, the impugned order is totally illegal, beyond jurisdiction, my lord.
But then we have passed this without hearing them. Returnable by 4 weeks, huh? The learned counsel to the petitioners to take the steps for submission notice upon all the respondents. Whereas to post to the age so and so, huh? Within 3 days. Within 4 days. Where is the Supreme Court judgment?
Supreme Court judgment, Gujarat,
Paragraph.
paragraph 33 and 34. Gujarat, madam.
heard on interim prayer. Next para. Considering the section 8, considering the provision of section 8 of the MSME Act 2000, the Act 2006, and also the judgment and order passed by the Honorable Supreme Court in the case of Gujarat State Civil Supplies Corporation Limited versus Mahakali Foods Private Limited, reported in 2023, 6 SCC 401. Come on. And also having preemptive view that the supply, the work contract may not be covered by the, may not fall within the privacy may not fall within the purview of MSD Act 2006. Forget that. Come on. In the interim, the impugn order dated so and so, both shall remain suspended till the returnable date.
Obliged.
This after 4 weeks. You just corrected it later.
Item number 10.
Take this. This one, this one.
Also, last occasion, the
6.
last occasion, the petitioner counsel wanted to file rejoinder in this matter.
Yes. Non appears for the petitioner on call. Mr. MS G at the London Initial Senior Government Agent is present. Come on. Office note dated 12/09/2024 reflects that no rejoinder affidavit has been filed by the petitioner, and the service report in respect of respondent number 5 is still awaited. Awaits service of notice upon respondent number 5 for further 4 weeks, list after 4 weeks.
Nice.
Item number 11.
Yes. To ascertain the address of respondent number 6 to 9 and take a fresh step. Heard, mister?
Yes, yes.
Heard, mister?
N Karga,
Huh?
N Karga.
And Karga, Land Council for the petitioner, and also heard MS. P. Sangita, London State Council for respondent number 125. 124. Whatever 5, who is for?
My lord, I'm for respondent number 5. My lord,
Mr. So and so for respondent number
my lord,
5.
I have a small prayer.
Just wait. Respondent number 5. Office note dated 12/9/2024 reflects that answered notice in respect of respondent number 6 to 9 have returned back answer have returned back. Mr. The learned counsel for the petitioners to ascertain and take fresh steps and file requisites. Mr. On filing of restitution notice. Then
My lord, we are no longer participating in this case.
why?
No, we are no longer representing the respondent number 5. So kindly our names may be strike out from the cost list.
Why? Have you sent a notice?
Yes, yes, we have been instructed by the petitioner himself, by the respondent himself.
Where is that? Have you issued a notice to the respondent number 5? That you are no longer in the, or he has taken the brief from you?
Yes, yes, I have been instructed by my senior counsel.
Well, consider you file an appropriate application. Or also as there any documents that he has taken the brief.
Okay.
List of Mr. So-and-so, learned counsel for the respondent 5 submits that he has. What is your submission?
To strike out our name from the cost list.
Submits that the name of the counsel from counsel on behalf of counsel representing the respondent 5 may be struck off on the ground that they are no longer representing the respondent number 5. How about the learned counsel, Mr. N. Singhe, your Tautarin?
For R. Sunar, Raja Sunar, on behalf of Raja Sunar. Myself, I'm M. Kambo.
Mr. M. Kamo so-and-so, appearing on behalf of Mr. R. Sunar, learned counsel for the respondent, could not substantiate, could not show any documents that he has been disengaged. The learned counsel, the respondent number 4 has been disengaged. The learned counsel for the respondent number 5 may take appropriate steps in that regard. This after 4 weeks.
Item number 12.
Well, I appear for the alleged contempt, my lord. I filed my affidavit.
Have you not complied with?
No, my lord. In fact, the order, it totally was passed basing on Mihin Laling's case, my lord, for payment of solicium and interest.
Where's the order?
Order in their contempt petition starts at page 9, and the relevant portion will be at internal page.
Are you ready?
No, your lordship.
Why?
Your
You
lordship,
should be ready.
your lordship, we have received the affidavit, your lordship. Your lordship, I may be allowed to take instruction from the petitioner, your lordship.
Huh?
I may be allowed to take instruction from the petitioner, your lordship.
Grant solution mentioned upon company which has already been fixed to be paid to pay for acquiring land for student program.
Question is only with regard to payment of solicium and interest.
So have you paid it or not?
The principal compensation amount has already been paid only with respect to solicium and interest. Solicium and interest, my lord, that matter, the state has filed an appeal before the.
Is the state?
Yes, my lord, we have annexed that. Earlier, the NHIDCL had filed, that was dismissed, but the state, my lord, has filed. That is our page 24, my lord, annexure 1. My affidavit, ma'am. This is with in Mean Laliang case only. Learned counsel for the petition submits that the acquisition are held in 2 separate legislation. One is under the right to fair compensation and transparency in acquisition.
So
Therefore, your lordship, I may be allowed to take instruction.
they are not able to, there's an inability to comply. Because they
Yes, Your
stay
Worship.
of the Honorable Supreme Court.
That's true, your lordship.
Or Mr. So-and-so, learned counsel for the petitioner. The Mr. N. Learned additional learned counsel for the alleged contender. Huh?
Yes, ma'am.
Submits that he has already filed affidavit. Affidavit in opposition placing on record that the basis of order, what is that order? Dated
Order dated 13/6/2023.
13/6,
13/6,
2023.
23, Your Lordship.
Passed in
Passed in-
WPC 56 of 2023.
In this,
Yes, in writ petition 56 of 2023.
by this court is pending before the with regard to the payment of with regard to the entitlement of solution with interest is pending before the Honorable Supreme Court, wherein the said this is within the direction for payment of solution within and the interest has been stayed, huh?
Yes,
List of Mr. So and so learned counsel for the petitioner. Press for and is granted 3 weeks time to obtain instruction. Press for and is granted 3 weeks time to obtain this. This
Much
after 3
obliged.
weeks.
obliged.
Let us make it 4 weeks. 4 weeks, huh? This after 4 weeks.
Much
Obliged.
Item number 13.
No steps.
Your Lordship, we will take first steps on with regard to respondent number 2 and
Mr.
3.
Paying. Let it consent by the petitioner. Press for and is granted 3 days time to take 4 days time to take fresh steps for service of notice upon respond 2 and 3. MS so and so. What is the matter? What is the matter?
Your Lordship,
What is the matter?
it's about land compensation. Your Lordship. Land compensation, Your Lordship.
What is your response?
Oh, yeah, we, our affidavit is in typing, Your Lordship.
Hmm.
So need 3 weeks time, Your Lordship.
MS P. Pangolan State Council submits that the affidavit opposition, the response, the affidavit in opposition is under typing for which she prayed for
3 weeks time.
3 weeks time to file. If it is under typing, why 3 weeks time is required? Press for sometime, press for 2 weeks time to file the affidavit of opposition. This after 3 weeks, you will be still taking.
3 weeks, yes, Your Lordship.
Obliged, Your Lordship.
Obliged.
Item number 14.
Yes.
This matter relates to
Steps
construction.
not taken.
In this matter, I will pray for the disposal. Your Lordship has passed this.
See, Mr. More. Let us streamline the procedure, right? Unless there is urgency, why the matters are listed for motion, admission, orders, and hearing. Let us have,
In fact, what happened on 11th?
let us give some significance and importance to the procedure. In every column, you cannot dispose of the matter. Why this has been listed for order?
But in
There's a
fact-
reason. So I request you to let us adopt the procedure. I mean, maintain the procedure. I have seen you as a lawyer also. You always ready to argue the matter in all the, stages, which will be wastage of your time and everyone's time. Are you following me?
Yes, my lord.
Are you following me?
Yes, my lord. I agree. But in fact,
The- Have you realized yourself? You are ready to argue in every stage. Let us, I mean, what do we call? Let us introspect ourselves. Because there is a reason why the matters are listed for orders, admission, and hearing. That's why I'm asking.
yes, my lord.
But it may, in turn, it may also, I mean, gives you a trouble because you have to read every file. Suppose you have a 15 files a day, I mean, in a day. Can you prepare the 15 files in
Yes,
in one night to argue all the matters? So that's a reason. Today, this is listed for hearing the orders because no steps have been taken.
well, in fact, what happened was that on 11, my lord, matter was listed in court number 2, and I was in a division bench, my lord. So
Okay.
I could not attend that matter, my lord.
Acha.
Yes, that is the case only. Otherwise, my lord, this is the cover case, my lord. Your lordship has already passed the order.
No,
It
no.
says similar matter.
The issue has already been noticed. Notice has been issued, and you have not taken steps. That's the reason.
Yeah, yes.
Anyway, it's nothing has. I mean, no adverse order has been passed.
Yes.
Only it says non-appears for deputation on call. P. Sangeeta appeared. Issued. A notice has been issued.
Inadvertently, my lord,
You are supposed to take steps. What is the matter?
my lord, I'm just, my lord, in fact, this is a road construction, my lord, this trying to Tato, and it start from the Penny to Tato village, my lord. And the
Then
petition,
you take steps. Unless you want to get it modified, you cannot hear it. That too is listed for orders.
otherwise, there is already, my lord, you also have
Similar order.
similar order.
On next date, we will see. If you want to, who is the respondent number 2? Which respondent?
Almost all the government.
Which respondent you want to take steps?
My lord, this is represented by all the governments, my lord.
Commanding officer, Director General Border. Why performer respondents? So according to you, it's a covered case.
Yes, my lord. My lord, may I just see the page 200, my lord. Your lordship has already
200.
passed. Yes, my lord. Your lordship has already passed the order. my lord. Covered case, my lord. Let's start from, order was passed on 6/9/2024. Same stage of the lane, my lord.
What do you say? If it's the same streets,
This is motion matter only, was it last occasion?
no, they have annexed the page 201.
Yes, that I have.
If you agree, we'll dispose of in the same line.
I leave it to your lordship.
No. If you agree, this order was passed on agreement that the earlier, the
Yes.
earlier order of the coordinate bench covers the issue.
Yes.
If that is the case, unless why we should keep it
I have
pending?
seen that, lordship, but then in the same, similar matter,
Yes,
in another bench, after this order was passed.
yes.
Notices has been issued.
It's okay, notice has been issued.
Yes.
If you think that it has been covered, because it was not, prejudice the respondents.
Of course, Lord.
The respondent is you are the respondents. There's no private respondents.
Yes.
If you say that it doesn't cover, we'll hear you. But if you say that this is covered case, then why we should keep it pending unnecessary?
At this stage, I can't say if it is covered because
go through
lordship,
it.
these people, I don't know.
You go through it. We'll fix it next week. All right. What steps you are supposed to take?
My lord,
Why this has been said, Prudence takes to serve notice on remaining respondents. Okay. Because government advocate appears only for respondent 2 and 3. Earlier occasion.
Lordship, I am for 1, 4 and 1 and 4 only, Lordship. 2 and 3 is pending counsel.
You do one thing. You give, you serve a copy to the respondent 2 and 3 and 5 and 6. You have the standing counsel.
Yes, my lord. 2 and 3, my lord.
5 and 6 is by Mr. Kato.
5 and 6, my lord.
Mr. Esmo, learned counsel for the petitioner is directed to serve notice and serve a copy of directed to furnish copy of the red petition by notice to the respondent number standing counsel for respondent number 2 and 3. Standing counsel for respondent number 2 and 3, and also the learned DAJ for respondent numbers 2, respondent numbers 5 and 6,
5 and 6.
to respondent number to Mr. M. Kato, learned DAJ. The MS at the learned additional senior government is granted a week's time to go through the order passed by this court, which earlier order is which
My lord, is 200, my lord. What is in 200?
no
Earlier, yes.
earlier one
Earlier, is my lord, is in
147.
147. 145. It start from 145.
Judgment and order of this court. Which date?
The date 14/08/2020.
14/08/2024. 23. 24.
24, my lord.
14/08/2024. Passed in WPC
Is in page 193.
3 of 2023 and order dated 06/09/2024. Passed in WPC 393 of 2024. You go through, and if you have any confusion, have discussion with over the phone to the authorities. Any if there is confusion, we'll dispose of after a week.
Date may fix so that it can be disposed.
After a week, we'll serve.
19. Oh, 19, my lord. Oblige.
Yes, what about this matter? We'll see. Today or some other day?
Some other.
Yes. No, this code is, it's a last order. We can resume it too. And if you have any, it's up to you.
Okay. It's okay, it's up to the petitioner. It's up to the petitioner. If she is interested, then
At 2 then, Lordship, if, or it's up to your Lordship, of course.
Then let's have some,
Lordship.
let us have some free mind on Friday.
In that case, Lordship, can
When?
date be fixed after 2 weeks?
well,
Next week I might be, that matter is still going on.
Yeah.
It's been more than 4 times that we
You
have,
have already retired
yes, I've retired.
in this matter.
Yes,
You have already retired.
yes. Of course, I'm,
There is no urgency as such.
no, of course, no urgency now.
I have a privacy. This court may not like to allow the writ petition,
Lordship, but
considering all this, because that's the one reason this court would like to adjourn. Instead of adjournment prayer by the parties. Because it so happens, practically, putting all your, effort, if you cannot grant relief to the parties,
Yes.
it looks like eventually you have done nothing.
No, Lordship is not
It's okay.
required to do
I-
that.
That, I understand.
We are only, so
So-
far as my opinion goes.
Yes, you,
I mean-
you fix the date in it.
Yes, Lordship, can it be on? Lordship, can it be on 1st of October?
First of all,
All right.
so no further adjournment.
But I would like to, I would like to apprise this court that we have immense faith in your Lordship. It's not that we can win every case, but we have immense faith that will be heard.
Of course, as you do, we also try our best,
Yes,
to the best of our
yes,
knowledge and ability.
yes,
That's all.
oblige.
We're also, after all, we're also human being. There
Lordship?
must be, well, after all, we're also human being.
Yes, yes,
If it's not that Lord, literally,
yes.
in literal sense,
Mm.